Hi everyone, this is Swastika. I am student of Centre Queensland University, Sydney campus. As a part of my assignment, I am doing this video for Australian commercial law. The case I am going to talk about is related to intention to create a legal relationship. Before describing the background of case, I would like to define what is a contract. A contract is an agreement between two or more parties under which legal rights and obligations are created, which will be enforced in the court. Let's begin the background of the case. This case name is Mrs. Riches versus Mr. Hogben. This case is of 1986. This case is between son and mother. Mrs. Riches is 88 years old widow and her son is 64 years old, Mr. Hogben. Mr. Hogben used to live in United Kingdom with his family. Mrs. Riches pursued Mr. Hogben to migrate Australia, and if he agreed to do so, she promised that she gonna buy a house in name of Mr. Hogben. But additional, she put a condition that if he will look after her lifetime, she will buy a house in his name. After thinking about this offer, Mr. Hogben decided that he will come along with her mother to Australia. For the purpose of migration, Mr. Hogben has to sell his properties in United Nations at considerable loss, and he also have to give up his free rental council house in United Kingdom. After coming back to Australia, the scenario was little different. Mrs. Riches bought a house in her own name instead of Mr. Hogben, and also ordered his son to leave the house and family after only 7 days in Australia. In this case, Mr. Hogben tried to sue Mrs. Riches for breach of contract or promise. For analyzing this case, I will be using IRAC method. In this case, Mr. Hogben is plaintiff who tried to sue for the breach of the promise, and Mrs. Riches is defendant. The issue of this case is whether the consequences was serious enough for the plaintiff if the defendant go back to the ward, and is this case is reviewed that the pre-assumption whether the party do not intend to create a legal relationship. With this question, let's look about the rules. In this case, there is no any written contract between defendant and plaintiff. That means there is no any intention to create a legal relationship. So this case cannot be bind and or enforceable contract. The application of this case falls under family, social and domestic agreement. According to the law of Australia, if there is any issue related to family and social, the case of this is not the case of binding in the court. Although this is a family family issue, but in this case, Mr. Hogben has considerable loss and considerable expenses by the broken of promise by Mrs. Reed. So this in this case also lies under the other family agreement. Talking about the conclusion of this case, as the case found that there is no any legal intention to create a contract or be in a contract by the party, so there was no any evidence of enforcement or punishment for breaking the promise, but the considerable loss and the seriousness of the case was something that the court look after, or it should be take into account. This case can be also taken as a priority staples, or this can also fall under the Property Act or law according to the nature of the promise, but the property to her son name and remedies to allows Mr. Hogben to live in her mother house. The result was finally in favor of Mr. Hogben. Mrs. Rich was ordered by the court to rename the house in his son's name, and she was taken as a trustee of the house for the benefit of her son, and this case was entitled Under the Right to Live in Granny Flat. This is all about the case. Thank you for watching this video. Thank you.